Let's proceed.
Good morning, Mr. Chief Justice Ireland, members of the panel, Clerk Mellon. My name is Stephen Pfaff. I represent Mullen and McGuiness in this matter. Very briefly, procedurally, how this case came before you is that my clients were terminated as employees of the Department of Correction. I then appealed to Civil Service. Civil Service had a hearing, and the Civil Service Commission voted in a majority vote to overturn the termination. The DOC then appealed to the Superior Court, and Judge Troy issued a decision effectively indicating that the hearing officer was biased in favor of my clients and asked that the entire matter be reheard without the hearing officer taking any part in the hearing or voting in any decision.
And the hearing officer was a member of the commission, I take it?
Yes, it was, yes, Commissioner Henderson, now off the commission, but yes, that's correct, Justice Bosswood. Hearing was held before Dollar Magistrate Judge Fink. She recommended just the opposite of the previous hearing officer, Henderson, and then presented her decision, as she must, to the full commission. And on June 12, 2008, the full commission voted 2-2 with respect to adopting her recommended decision and findings. We're here because I suggest to you that 2-2 vote really has no meaning effectively at this point, but the DOC has determined and the Civil Service Commission has determined that, to use a baseball analogy, if I may, the tie goes to the runner and they are the runner. And therefore, by default, according to Justice McIntyre, what must stand as the final decision is the decision to terminate my clients. And I suggest to you that's incorrect.
Before you get warmed up, to use a baseball analogy, it was decided first by a member of the commission. It was. By himself.
The process in front of the commission, Justice Gant, is that a hearing officer is designated by by the full commission. That hearing officer hears the case, evaluates the evidence, judges the credibility of the witnesses, presents findings and facts to the full commission. They vote whether to adopt the same.
But when Henderson made his decision, did that go to the full commission?
Yes, it did.
Oh, it did?
Yes.
Ah.
In a 3-2 vote, they adopted his findings of fact and overturned my client's termination. That's what forced the DOC to appeal.
So it was not only the Henderson decision, it was the 3-2 vote by the Civil Service Commission.
Correct.
I
That's
see.
correct.
And was when Judge Troy, okay, you couldn't appeal from that because he remanded it? Is that?
He sent it back for a full hearing, that's correct, with instructions that Henderson not hear it or partake in any voting. I'm here to convince you that the analysis used by Judge McIntyre that says that a 2-2 vote means default going back to the last standing decision, that is to say the one by the Department of Correction terminating my clients, is incorrect. I think the proper analysis would have been at that point, what does the rejection of Magistrate Fink's recommendation mean? And I suggest to you what it means, that there's been no determination under the Civil Service Statute, Chapter 31, at this point, as to whether or not basic merit principles were afforded my clients based on the DOC's decision. And as we stand here today, that's the question. Nothing has been afforded to them by way of Chapter 31. And so I think the remedy in this case has to be that exactly what Judge Troy did, and that is to send it back and have a full hearing and a vote determining basic merit principles.
Okay. Your brief depends a great deal on 801 CMR. But
Yeah.
the question is, since those apply to 30A proceedings and the civil service isn't governed by 30A, I don't see why that...
Yeah, good question. Excellent question. It's mentioned in footnote 4 of Judge McIntyre's decision. She says there is a substantial question as to whether or not 801-101 actually applies here.
But your argument today seems a little different. Is that right?
Well, my argument today is effectively whether or not they do apply, Judge, and I can't find anything in Chapter 31 indicating that the Civil Service Commission has adopted 30A, but for the fact that, according to their website, 801 CMR 100 applies to all authorized hearings conducted under Chapter 30A, including DAWA and Civil Service Commission hearings. That's what it
That's
says.
what the commission says?
That's what it says. So and I can't find anything by way of a vote adopting 30A.
But for 30A, Section 1 defines agency to exclude the Civil Service Commission.
That's exactly what it says.
But you're suggesting, that would suggest that whether it's excluded by statute, it has chosen to follow those rules. Is that right?
I'm not so sure. That's what the language says. I'm not sure simply by saying it without the benefit of some sort of vote that's effective. I think, however, at the end of the day, whether or not 801 applies is really not the issue.
yeah, and
What
that's-
the issue
okay,
is
yeah.
what does a 2-2 vote mean?
Right,
Because
and you-
ultimately, at the end of the day, whether 801 CMR 100 applies or not, you're still left with a 2-2 vote.
And so and can you explain what you mean when you say something about you have to remand for basic merit principles? How do you get there?
Sure. Under Chapter 31, Section 2, the whole appeal process with respect to someone who is governed by the civil service rules is that you get the right to say or argue if you've been disciplined, or in this case terminated, you get to say whether or not basic merit principles applied to your case, i.e., essentially, was there any politicalization in terms of the decision-making process? Was it fair and not arbitrary and capricious, or was it based on something else other than a fair hearing? That's effectively what it says. Because there has been no decision, as we stand here today, on that very argument, on that very matter, I suggest to you the only way to have that determined at this point is to send it back and have a hearing that ultimately will get decided by a vote by the full Civil Service Commission.
Is the commission now comprised of a different set of people?
Yes, the commission is now comprised of a different set of people. The reason why it's a 2-2 vote is that Henderson had to abstain
Right. So
from
we've
that
got
for-
five new members, or at least, anyway, not Henderson.
Not Henderson, right. There are some different members.
There's 5 members who can sit on this case, is what you're saying.
Yes, right now there are, correct. But unfortunately, throwing a bit of a wrench into the entire picture is the fact that after Magistrate Fink issued her decision, she's now retired, by the way, at this point, I filed, pursuant to their request, objections to certain of her findings. Those were never addressed. If, in fact, 801 CMR applies, I think it's 11D or E that effectively says, actually, I think it's 11E. It's 11D. A final decision of the agency, that would be the commission, shall make appropriate response to any objections filed in regard to an initial or tentative decision. I made those. There's no objection by the other side that my objections to Magistrate Fink's recommended findings were anything but timely, and there's been absolutely no response with respect to that.
And now she's gone.
Now she's gone, exactly.
So who's going to respond to your objections?
That's the $64,000 question.
Have you thought about filing your objections? If you prevail in this case, maybe we should give you time to go back to them with your objections.
The objections have been filed. What I'm looking for effectively is a response from them, and I suppose that would be one of the remedies, because one of the issues also presented in my brief is the credibility, or strike that, is the reliability that the magistrate used with respect to evaluating the evidence. And I tried to poke some holes with my objections onto that very issue. So the fact that they haven't issued any decision whatsoever on my objections, I think, is a fatal flaw in the process.
I thought before you answered Chief Justice Ireland's question that what you were seeking as a remedy is to start back again.
that's
you want
right.
a whole new hearing.
I want a whole new
before
hearing. Yep, just exactly.
one of the commissioners sitting as a hearing officer. Is that
Exactly,
right?
exactly. Just what Judge Troy did in the initial instance. He sent it back for a full hearing. That's exactly what I'm looking for. I was specifically addressing your question, Mr. Chief Justice, on the objections, but that should be an issue that should not be overlooked. The fact there has been nothing but a cursory response from the Civil Service. In their June 12, 2008 decision, they say, after careful review and consideration of the magistrate's recommended decision, and the comments of the appellant, as well as acknowledging the comments of the appellant received by the commission. Those are my objections. They don't say anything about the objections, and I think in order to do that, they would have had to send that back to Magistrate Fink, which is no longer the process because she's retired.
But that depends upon 801 CMR applying to a civil service proceeding. Because only there is there the obligation to answer your objections.
I think, given the fact that I was asked to actually file them, I think whether or not this case falls under 801 CMR, I am entitled to a response to them, given the fact that I was invited to file them. And to
Entitled by what?
Entitled by the fact that I was simply asked to respond. There's nothing I can point to you other than 801
Right, and if that doesn't apply, it's just a
correct.
question. And not only that, I mean, are we looking at it and are we looking to see whether it was supported by substantial evidence? So even if she turned down all of your objections, we could still look at it and determine whether that was substantial evidence.
Certainly could. Yeah, you certainly could.
And
My argument is based on process, though. The fact that they haven't responded is a hiccup, if you will.
And your claim for an entitlement to an entirely new hearing, is that based solely on the failure to respond to objections, or would you say that apart from that, you're entitled to a new hearing?
I think I am entitled to a full hearing, given the fact there was no majority vote
Okay, you
reached
say to a
by the
full
full
hearing,
commission.
but are you asking for a new evidentiary hearing before a
Yes.
new hearing? Is that only because of the objections not being answered, or for some other ground?
I'm asking for a full hearing also because of the vote was a 2-2 vote, and there was no decision made to adopt Magistrate Fink's finding.
Why wouldn't it be a remedy that I mean, the hearing was before, obviously, Magistrate Fink wasn't a member of the commission, so everybody who was part of that 2-2 vote was reading a transcript, I take it.
Correct.
Right? So why wouldn't it be an appropriate remedy to send it back to the now 5-member competent, in this case, commission to look at again? In other words, not another evidentiary hearing is what I'm saying.
It's not an inappropriate remedy, something like that to happen. But given the fact that the entire process has been flawed with respect to the lack of a majority vote, with respect to the lack of a response to my objections to the recommended decision, I think the only way out on this, respectfully, is to send it back. It's been done once before with Judge Troy. So I'd ask that that any remedy in this case be the fact that the entire matter be retried before a hearing officer, and then a full decision, a full majority decision be made from the Civil Service Commission.
But you would have that remedy only because of the fortuity that Mr. Henderson is no longer on the commission. I mean, what principle do we establish to say send it back to get a full 5 when this thing happens again?
If this thing happens again? To my knowledge, this is the first time this has ever happened, Your Honor, a 2-2 vote being appealed. There is a reference with respect to a civil service reporter decision from 1994 about a 2-2 vote, but nothing has risen to this level before. I think that respectfully, the decision has to be you need a majority vote coming out of the Civil Service Commission, period.
Well, the statute says, where am I looking for?
31-2? 2B?
So it has to be an affirmative vote of at least 3 members of the commission in order to
Right.
undo what the Department of Corrections did. That's what the civil service statute says, an affirmative vote by...
Not to undo. I think it has to be a 3-member vote to reverse or modify.
To reverse or modify, and that's what you're seeking here. You're seeking to have the Department of Corrections decision reversed or modified.
Ultimately, yes.
Right,
But the
and
vote
so
that was
in order
taken
to-
with respect to the Civil Service Commission in June of 2008 was not to reverse and modify, very respectfully, Justice Link. It was simply to adopt to adopt the facts and recommendations of the magistrate.
The magistrate who was seeking to affirm the Department of Corrections.
Yes.
So if the Civil Service Commission wanted to reverse or modify instead the Department of Corrections, they would need an affirmative vote of at least 3 members of the
Yes.
commission to do that.
That's what 2B says, right?
So really, all it says, really, presuming this statute, there ordinarily would be 5 members of the commission.
Correct?
But presumably, you don't need any more than 3 members of the commission at any given time to act.
I think you need 3 members to vote affirmatively. That's how I read 2B.
Can you have it? So are you saying that there's an invalidity when you have just 4 members sitting? That you have to have all 5 people all the time? Because there's no way you can, because there's always a risk of a tie?
I think the invalidity is the 2-2 vote. and
So
nobody
only
knows
when
what
they
to do.
tie, that 4 is not enough?
I believe that's correct.
Thank you, counsel.
Thank you, Mr. Chief Justice, members of the panel.
May it please the court, Chief Justice Ireland, members of the panel, clerk. Carol Colby for the Department of Correction. The Civil Service Commission did not err by dismissing McGuiness and Mullins' appeal here on a tied 2-2 vote. The appellant's argument rests, as you've already appreciated, on an erroneous premise that the standard adjudicatory rules of practice and procedure apply to the commission.
Well, if their website, I understand a website doesn't mean it's legally binding, but how do you explain the fact that their website says it does apply?
Well, I would submit that, in fact, the statute provides that it is excluded. And therefore, I would suggest that although they may use the rules, they're not binding on the commission.
Oh, they could make them such.
But I would submit that they cannot trump the statute, which excludes the
No,
Civil
well,
Service Commission.
30A does. It doesn't mean that the Civil Service Commission can't adopt certain procedural rules as binding on themselves without being subject to 30A.
I appreciate that, Your Honor. I would submit that Section 2 governs this situation here, though, that Chapter 31, Section 2B specifically provides that no decision or action of the appointing authority shall be reversed or modified except by an affirmative vote of at least 3 members of the commission. And you'll note that Section 2 provides that all references in 2B shall refer to the local appointing authority. In absence of 3 affirmative votes here, the commission's hands were tied. The commission had no choice but to dismiss the employee's appeal.
Is there anything anywhere that speaks to how many people have to be sitting at any time?
Yes, I would submit there is actually, and I would submit that this, there was actually a misreading when the appellants argue that there's a required majority based on a particular section. I will show you. In in 801, in 801D, the final decision language, 1.01, D provides that a majority of the members constituting the agency or the agency panel authorized by the agency to decide the case shall make direct agency decisions. That is what we had here. We had 4 members of the commission voting out of 5.
So you are saying that 801 CMR does control?
Well, I would submit if, in fact, this court finds that it does, Your Honor, then that language is what would apply here.
Go ahead.
Moreover, in the absence here, and I'm sorry, I would submit that the Barcelou case is.
Sorry, before you leave that point, I'm not sure what the consequence is. You say the majority, if you say that the provision applies,
Yes.
the majority of the members constitute the agency or the agency panel, but there was no majority.
That is correct. What I'm saying is it says the majority of the members shall make direct agency decisions.
Right.
And I would submit that because there was a tie, you look to section 1.0111C3. And I would submit that because there was a tie vote, 2 in favor of the termination decision and the magistrate's decision, and 2 against. While there's no provision governing tie vote situations here, section 1.0111C3 provides if the agency fails to issue a final decision within 180 days of the filing or refiling of the tentative decision, their initial decision, here that of Magistrate Fink, upholding the decision of the Department of Correction to terminate, shall become the final decision of the agency, not subject to further agency review. So I would submit that that applies. This case should not be remanded.
What section is that one that you just read?
It is in 1.0111C3.
So that's chapter 31, section 11C3? No.
No, that's in the
Regs.
801
These
CMR.
same regulations?
Yes.
Oh. Could I ask you, this is under the heading of obtuse question, but looking at section 2B, it talks about, it says the Civil Service Commission may not reverse a decision of the administrator. Now, the administrator is a defined term, meaning the administrator of the Division of Human Resources. That's not
Actually,
what, right?
I'm
So
sorry.
where am I wrong? I mean, I know that's not correct, but how do I fix that?
Excellent question, Justice Botsford. Actually, you refer back, you cross-reference section, chapter 31, section 2C, which provides that all references to the administrator shall mean local appointing authority.
Yeah, but the Department of Correction isn't a local appointing authority.
Well,
It's a state agency.
I would submit that it does
I did
apply
that,
to
and
the
then I got
Department of
lost again.
But
Correction, but even if it didn't apply, you still would not have any determination that would favor the appellants here, because you then go to 1.0111C3, whereby we have the tied vote, and which favors the Magistrate Fink's decision.
So you're saying that Judge McIntyre was incorrect in at least the first part of her decision, which said that the consequence of the tie vote is that there's no appellate review.
I don't believe Justice McIntyre.
Well, she said there's no decision, and therefore it's dismissed.
Well, that's true. She did say that in fact, with the lack of a majority vote, ultimately, results in dismissal of the charges. Dismissal of the appeals. Therefore, the department's decision stands.
But what that means is that these two, Mr. McGuiness and Mr. Mullen, can secure no judicial review. Is that really, do you think, what's contemplated?
Well, I think they have had judicial review here.
Well, but not of the final decision.
Well,
I mean,
they-
if you accept her, if she says it's dismissed, I mean, the first part of her decision says it's dismissed, there's nothing to review, end of this story. She goes on, but that's what she first says. So if we take that as the governing principle, there would be no judicial review of the substance of Magistrate Fink's decision or what the commission did with it, right?
That is the way it would appear, yes, from that decision.
But I thought you just told us that that's not right, that there is a final decision here, and that it is by Magistrate Fink, and that can be subject to review for substantial evidence.
But
Well,
that's
I
if
would-
you apply 801 CMR.
Correct. That's if you apply, if this court chooses to find that those rules apply here.
Okay, and you're saying we shouldn't, or we should?
Well, I would submit that they are do not apply here, because the statute specifically excludes the commission, and that although that the website, I guess, does say that they apply them, that they are not binding.
Okay, but the consequence of that argument is that these individuals are worse off by a tie vote than they would have been if they had lost 5-0. Because if they lost 5-0, they could then appeal to the Superior Court and have that decision reviewed for substantial evidence. But you're saying because they got 2 votes and it's 2-2, they get no review of the substance of the decision. How can that be?
Submit that if you look at Chapter 31, Section 2, you need to reverse or modify the decision, you need at least 3 members of the commission affirmatively to vote. And I would submit that statute controls here.
So the effect of a tie vote essentially is an affirmance of the magistrate's decision.
The effect of I'm sorry, could you?
The effect of the failure to get 3 votes of the commission
Yes.
results in an affirmance of the magistrate's decision, which is then reviewable in court. Right. On that basis, it's reviewable as an affirmed decision. That becomes the decision of the board.
You could look, yes, Your Honor.
Well, there's 2 ways to look at it,
You could look at it that way, or you could look at it that it was dismissed because of the absence of 3 affirmative votes. The commission's hands were tied, and therefore it's dismissed. The appeals are dismissed, so the decision of the Department of Correction.
Suppose it had been on the 4 members of the panel, a 3-1 vote saying we uphold Magistrate Fink's decision. Same result can go to Superior Court for review of, I mean, is the action then dismissed because Magistrate Fink's decision is upheld? Or what happens if it were a 3-1 vote, instead of it being by default upholding Magistrate Fink's decision, but affirmatively upholding Magistrate Fink's decision, which, basically upholds the Department of Correction position? But what's the difference? Is there a difference there?
Well, I would submit there is a difference. One, you have the statutory 3.
No, because they're not, I suppose they're.
Oh, I'm sorry. You said in favor of
Yeah.
I would say that there is a difference. It would be able to then be appealed by the appellants. And I would submit that the 3, that you would have a majority vote there to adopt the magistrate's decision. Here, we had the 2-2 vote. And so by a tied vote, it's clear from the Civil Service Commission's ruling that they are not adopting any decision, that they're dismissing the appeals.
So let's say it's a 2-2 vote, and we say that the consequence of that is that the initial decision becomes the decision, the sort of the consequence under 801, right? And so let's say that is appealed to the Superior Court, and the Superior Court decides that it is the underlying decision is not supported by substantial evidence. What's the remedy? Sending it back for a new hearing? Because clearly without 3 votes, there's no authority for the Superior. I mean, so what would be the remedy? Would it just be another hearing?
You're saying that the initial decision, the underlying decision is
appealed.
Is appealed, and then substantial evidence is.
And the Superior Court says this is not supported by substantial evidence. Consequence is another hearing?
Could be another hearing, or the court might find that.
The court reinstate?
Because of the lack of substantial evidence, then the they might find in favor of the appellant.
Okay, so even without three, so the court can essentially override the statute, which requires 3 votes of the commission to alter or modify or reverse.
It's a unique situation. I would submit
An
that.
enigma within an enigma, never mind.
It is. I would submit that it's clear that the Civil Service Commission, Commission's position is that as they found in Barcelo versus Holyoke Department of Public Welfare, MSC 232, 1994 decision, that the Commission denied an employee's appeal because a majority of the Commission did not vote to modify or set aside the action of the appointing authority in terminating the employee. Here, we do not have a majority vote. I don't think that there's any dispute between the parties that we do. We do not have a majority vote. And that case, as I mentioned, has been the law of the land, if you will, for the Civil Service Commission and for the parties that practice there since 1994.
What's the basic principle of that case?
That is that if in the absence of a majority vote of the commission, where a majority did not vote to modify or set aside the action of the appointing authority in terminating the employee, this appeal was dismissed and the underlying determination by the agency stood.
I take it that when you say absent a majority vote, you're talking about a tie vote. Because obviously, as Justice Lange's example of 3-1 upholding a decision of Magistrate Fink, that's an absent of a majority vote for reversal, but it is a majority vote for upholding.
That is true.
So it's really, so Bartolo was a tie vote also?
Actually, I understand that it was not a tie vote. It was not a majority of the commission. So we really do not have a case that I'm aware of that presents itself as this one does. But I would submit that we do not have a majority vote here, and therefore this, the dismissal by the Civil Service Commission and thus the failure by the Civil Service Commission, if you will, to act in with a majority to overturn the decision of the agency, then the decision of the agency stands here.
All right, thank you very much, Counsel.
Thank you.